Hello, everyone. This is Arthur Sternberg at the Chicago office of Thompson Coburn, along with my colleagues Mike Duffee and Susan Lorenc. Welcome to our presentation on the I on workplace privacy. Our presentation is 50 minutes long and covers pre-employment and application issues, issues during employment, and post-employment issues. There's a lot of material to cover. In general, there's a trend towards the courts and agencies decreasing the protection of employer privacy while increasing the protection of employee privacy. And I think you'll hear that as a consistent theme, but there's a lot of things that we as employers need to know. So we're going to start with Susan Lorenc on pre-employment application issues.
Thanks, Art. I'm going to start by talking about restrictions on background checks. This is something frequently done by employers as a routine matter, and most of our clients are surprised to hear that there are some restrictions on this. But it is something that has become a hot-button topic with the EEOC and one we feel is important for all of you to know. Pursuant to the Federal Fair Credit Reporting Act, which is enforced by the Federal Trade Commission, there are requirements on the parts of employers before they can proceed with conducting background checks via third parties. In order for an employer to do a background check on an applicant or an existing employee, they have to first provide disclosure and receive consent from that individual. This needs to be a conspicuous document. We recommend that it's separate from the application itself, that clearly states what it is that the employer will be searching and how it is that they will utilize this information. Reports that are provided by third parties about an individual's history includes matters such as health, educational information, criminal convictions, prior addresses, and past employment. All of these are covered under the Fair Credit Reporting Act. If the background check uncovers some information that the employer is concerned about, which may give the employer pause in hiring, they then have to proceed with giving the applicant a pre-adverse action letter that includes information about who did the search, how the applicant can contest that information, and the information about the provider who they can contact. You then are obligated to give some undisclosed amount of time, and unfortunately the Federal Trade Commission is not consistent in its time frame, but we recommend a business week before taking the adverse action, i.e. not offering the position to the individual. And then if the employer decides not to make an offer, they have to give what's called an adverse act letter that again reiterates their rights under the Fair Credit Reporting Act. Unfortunately, the analysis does not stop with what the Federal Trade Commission requires. We now have to look at its interplay with the EEOC that is clearly doing a deep dive into the way in which employers are using background checks to weed out applicants. The EEOC has taken the position that background checks disparately impact certain minority groups, namely African Americans and Hispanic individuals, and therefore they really want to scrutinize the way in which we are applying our background check policy. Therefore, it is incumbent upon employers to take a look at the job relatedness of the background check and make sure that it is consistent with the business necessity, i.e. if you are doing background checks on all of your applicants and you are choosing not to hire someone with any sort of a criminal conviction, even though this person might only be charged with answering telephones or sweeping the floors, a EEOC investigator might find that that is not related sufficiently to the job and is not consistent with your business necessity, and they therefore might choose to investigate your business and bring some sort of disparate impact charge against you. The Illinois government has taken a further approach on this and has decided to enact the Employee Credit Privacy Act, which forbids employers from inquiring about an applicant's or employee's credit history or obtaining a copy of their credit report. And again, this is credit history, not necessarily one's criminal history. unless the position involves bonding or security per state or federal law, unsupervised access to more than $2,500, signatory power over business assets of more than $100, management and control of the business, or access to personnel, financial, or confidential information, trade secrets, or state or national security information. There is no similar law in Missouri. However, a handful of other states, including Hawaii, Oregon, and Washington, have similar laws. So therefore, any sort of across-the-board policy, if you're an employer in Illinois that says we are going to do a credit check on all of our applicants, might not pass muster unless we can clearly show that each applicant falls within one of these exemptions. Illinois has taken this issue a step further and is currently in the process of passing the Illinois Job Opportunities for Qualified Applicants Act. This bill began in the House. It was passed out of the House on May 23rd and passed out of the Senate on May 29th, and is currently before Governor Quinn for signing, which we fully expect him to do. The Act would bar businesses with 15 or more employees, so a very low threshold, from inquiring about or requiring applicants to disclose criminal records before the employer has offered an interview or made a conditional employment offer. So if you are the type of business that doesn't require interviews of your applicants, the conditional employment offer would be key. Once the interview is offered or a conditional offer is made, the employer would be free to conduct the background check, but it cannot be something that's done in advance of the interview or conditional offer. Once again, Missouri does not have a similar law, but a handful of other states are definitely going down this path. So once we get beyond the concept of background checks and credit history checks, we see a trend in employers wanting to access employees or applicants' social media in order to get additional information that you might not otherwise get from an application. One of the first things that I should point out is that it's unclear, and the FTC has not come out and said whether or not this would be included as a background check. Certainly if it's done by a third party, it would be covered by background checks. But if it's done by the employer itself, it probably would not be included within the Fair Credit Reporting Act requirements. That being said, there are obvious pitfalls involved in accessing an applicant or employee's social media page. The information itself might refer to the wrong person with the same name. If your applicant is Bob Smith and you've never met this individual, you have no way of confirming whether the LinkedIn page or Facebook page that you're looking at is in fact your Bob Smith. The information may be outdated. There might be verbiage on there about I really hope to get my GED someday, and you are making a decision based on the fact that this person is not a high school graduate, when in fact that information may be outdated and this person is otherwise meeting the job qualifications we've included in our job description. Others may be posting false or misleading information about the individual. People with vendettas, spurned ex-boyfriends and girlfriends. The possibilities are endless. But more troubling from our perspective is the way in which we might be exposing ourselves to additional obligations by searching through someone's social media. There could be an obligation to retain any records that we've received if we see that there's postings on there and we've made copies of it. If that is something that state law would dictate as part of a personnel file, then we automatically have an obligation to retain those. Plus, there are new electronic discovery rules that are ever evolving, and so if someone ends up suing us for a discrimination claim, which I'll get into in a moment, we have discovery rules for our accessing of social media that would kick in. And in the absence of retaining those copies, we could face a spoliation type claim. So how will this open employers up to discrimination claims? The following is a sample of what you might see when searching an applicant or current employee's Facebook page. So on this page, we see the individual's gender, which may or may not be obvious from the application. We see their marital status, which may or may not give reference to the fact that this is a heterosexual or homosexual, depending on the jurisdiction. We also see their political affiliation and their religious views, all of which are information that we would typically not get in a job application, but which could open us up to a claim of some sort of protected characteristic that led to our decision not to hire or promote the person. You also see towards the bottom their high school and college graduation years, so you can deduce their age. Again, this might be someone that from the face of the application, we only know their name, their address, and their last places of employment. Now, by accessing their social media, we have knowledge about their age, about their sexual orientation, about their political affiliation, and their religious views. Now that we have notice of that information, any decision we make either to choose not to hire the person or not promote the person is inferred to be with that information in mind. So from that perspective, unless there is a very strong, non-discriminatory, legitimate reason to be accessing an individual applicant or employee's social media page, it is our recommendation that we steer clear of that. It creates more problems than I think it actually prevents. Illinois has responded to the growing concern of accessing employees' social media by passage of the Right to Privacy in the Workplace Act. The Act, which was passed in 2013, made it unlawful for any employer to request or require an employee or prospective employee to provide any password to gain access to their account or profile, or to demand access in any matter to any employee or prospective employee's account or profile on a social networking website. Now, quite frankly, I've yet to hear of any employer who's asking for the password itself. That seems a little extreme. However, it does seem more likely that an employer might ask to be, quote unquote, friended to an individual so that they can gain access to the account. And pursuant to this Illinois State Act, that is prohibited. There are currently similar bills before both the Missouri House and Senate, but nothing's been passed into law at this point in time. This is also a growing trend around the country, and to the extent you are not in Illinois or Missouri, I would encourage you to investigate the current state of your jurisdiction's laws on the topic. We're now going to switch to issues surrounding workplace privacy when your individual has been extended an offer and is now an employee of the company.
Thanks, Susan. This is Art Sternberg again. So now we're going to look at what are the privacy concerns during employment. The first is, what can the employer do in monitoring and investigating employee conduct? So we're looking at what can the employer do. In a minute, we're going to look at what can employees do and what can employers do back regarding surveillance and recording. So first, from the employer's perspective, can an employer videotape and follow and audio record employees as they're doing things? Well, the biggest restriction is the Federal Wiretap Act, and every state, most states at least, have similar statutes. So Wiretap Acts restrict using any electronic device to intercept, to monitor, to record wire or oral communication. So that could include even just a conversation between two employees using some sort of device to be able to hear that conversation where you wouldn't be able to do that. Federal law applies where there's no consent given. So you need at least the consent of one party to that conversation. The Illinois eavesdropping law was even stricter. You had to have two-party consent to it. However, that law was struck down, and a replacement law died in committee in this past legislative session. Missouri has no statute, so eavesdropping in Missouri is perfectly fine statutorily, but there is a common law right to privacy that all of us have as employees. We also have a right against false light publicity. So, for example, our right to privacy would be violated if we were recorded while we were in the bathroom or while we're in our own homes. A false light publicity might be unflattering portrayals of employees that somehow managed to get posted to YouTube. So an employer in that situation could be sued for false light publicity or right to privacy. The National Labor Relations Act also applies even to non-union employers against surveillance of employees engaged in concerted activity, which my partner Mike Duffee will be speaking about more. But you can't photograph or film employees engaged in certain protected conduct, such as in-plant march in support of wage demands. So now we're going to look at sort of the flip side of that, and that is the right to restrict employees from video recording. The employer has a very broad right to restrict, punish, terminate employees for recording other employees or anything in the workplace, except with two exceptions. One, when it's part of a concerted action, which is what I was just talking about, that employees are filming something that would be part of their concerted right to advocate for better terms and conditions of employment for a group of employees. The second one would be when an employee is protecting an individual right. Now, this is a tricky one, and there's almost no case law that I've ever seen on it. But let's say that an employee is videotaping sexual harassment of that employee or even another employee. There's a good chance that a court would say that that's protected conduct under Title VII of the Civil Rights Act of 1964, in addition potentially to under the National Labor Relations Act. So disciplining an employee for making that recording could violate the employee's rights. However, I want to make clear that there's no restriction, there's no violation of a right in prohibiting an employee from insisting on recording or surreptitiously recording a meeting with a supervisor or a manager. So again, if an employee says, can I record this, or I insist on recording it, your answer is going to be no. And if the employee does it, you're still going to discipline. Of course, you're going to talk to us first to make sure that there are no problems. All right, so now we're going to look at, in a little more detail, what do we say as justifications if we catch an employee or we're trying to dissuade employees from engaging in audio recording? Because, employees in Illinois may know that the Illinois law was struck down. Well, as long as it's not protected audio recording, which we just covered, then, yeah, you're free to go ahead and terminate the employee because there are business justifications. And I've cited a few of these on this current page. The recording may violate state and federal wiretap laws. It may violate privacy expectations of other employees or customers. It can interfere with employers' responsibilities to those employees and customers. It disrupts the work focus and place, and it may lead to the misappropriation of trade secrets. Now, a particular focus should be, what about monitoring phone calls and recording telephone conversations? Because those have a special place in the law. So the Federal Wiretap Act, which we talked about before, prohibits interception of oral communications, which include telephone conversations, and it doesn't matter whether that's by cell phone, land phone, voice over internet. Now, here's an interesting twist, is that there's very little restriction on videotaping. As long as you're not videotaping in a private area like a bathroom. But there are these restrictions on intercepting or recording oral communications. Now, a lot of employers have videotaping systems that also have audio recording capabilities. And there's no consent, at least not expressed. There could be implicit consent, but an issue should be raised for anyone who has a video recording system that also captures audio as to whether they're violating the Wiretap Act or anything else as to conversations that are going on between the persons who are being videotaped. As we mentioned before, the Illinois restriction on eavesdropping was struck down in March of 2014. The Missouri restriction is only one-party consent. And again, we have that common law right to privacy and to a lesser extent in this context, false light publicity. The final thing that I want to point out is that California has some unusual laws. It has 2 laws that prohibit recording telephone conversations without a period. I mean, you can't record them even with consent. The interesting thing is that it can apply to telephone calls that are made from California to out-of-state locations. So theoretically, you could be sitting in Missouri and violate California criminal laws by having a call center in Missouri that takes telephone calls from persons in California and records them. Now, I don't think that's much of a concern unless your business has a presence in California. Then it's a real issue. I apologize that I talked a little fast in going over those points, but I wanted to give enough time to my partner, Mike Duffee, on the NLRB issues.
Thanks, Art. Going back to what Susan talked about a short while ago regarding social media and monitoring by employers, the National Labor Relations Board has, as you might expect, quite a bit to say about the extent to which employers can discipline employees for what they post on social media or on the internet. And keep in mind, this is true whether you have unionized employees or whether you don't have a union for your employees. Rules that we're going to talk about apply equally to both. And for many years, the NLRB has agonized over the extent to which it will allow employers to make and enforce work rules that limit what an employee can say or do on the job and still protect the rights of employees under Section 7 of the National Labor Relations Act, which allows employees to engage in union activities or what they call concerted activities, which means activity by 2 or more employees for the mutual aid and protection of employees in the workplace. The test the board's traditionally applied in balancing these rights is the Lafayette Park Hotel case, whether the rules would reasonably tend to chill employees in the exercise of their Section 7 rights. Well, what does that mean? Well, the board looks at whether the rule restricts union activity directly or whether it punishes employees for talking about or taking group action against work policies that they don't agree with. If employees can reasonably construe the work rules to interfere with these Section 7 rights, the employer cannot make or enforce those rules, and obviously any discipline that results from application of those rules will result in reinstatement and back pay for disciplined and discharged employees. Depending on the makeup of the board, which currently is 3 Democrats and 2 Republicans, the board may look at work rules and policies much more, carefully in order to find a violation, sometimes where the resulting violation may not be obvious to a person of normal sensibilities. For example, a case we cite in the materials, Adtrans Daimler-Benz case in 2000, an employer ruled that forbid employees from using, quote, abusive and threatening language toward anyone on company premises was held by the board to violate the act, since it could be conceivably construed by employees to outlaw lawful union organizing activity, not that it was in fact so applied or even interpreted by the employer in that regard. Also, another case we cite, Community Hospitals of Central California, the employer had a rule against, quote, disrespectful conduct by employees, which the board struck down since employees could again possibly construe that rule as forbidding criticism of supervision, which is something that the Act does protect. Keep in mind, when you look at this analysis, the board looks at the rules in the abstract and how the employees might understand the rule, not whether in fact the rule is written that way or does outlaw conduct specifically, which the board would protect. Courts, however, don't always agree with the board's analysis and some of its careful reading of employer policies. For example, in the Adtrans case that we just reviewed, the Court of Appeals in that case disagreed with the board and upheld the rule against employee use of abusive or threatening language, reasoning simply that since the civil rights laws require employers to have zero-tolerance policies regarding abusive or threatening language by fellow employees, the board's position basically placed employers in the proverbial catch-22, and the court was not willing to place employers in that type of a situation. Also, in the Community Hospitals case on appeal, again, the board lost. The appellate court found that the rule against, quote, disrespectful conduct by employees really did nothing more than invalidate conduct which was insubordinate or where employees were refusing to follow proper orders, and it didn't chill any employee-protected activity at all. So as you can see, there's a great deal of room for disagreement in these kinds of cases, and the employer is usually, as is typically the case in employment law, caught in the middle of this tug-of-war between the labor board on the one hand and the federal courts on the other. Unfortunately, the labor board doesn't seem in recent years to have followed the admonitions of some of the appellate courts, and is continuing to follow a pattern of finding violations by employers in what might be perceived to be unusual circumstances. For example, the board has struck down employer rules which, for example, forbid employees from, quote, bearing false witness, must be a biblical company of sorts, against the company or the coworkers, since the board found it could encompass deceptive statements, which apparently the board seems to think is protected under the Labor Act, which says much about the labor board, I guess. The board struck down rules which precluded employees from posting a vulgar or sexually offensive material on a bulletin board during a decertification campaign, which is kind of surprising that the board concluded this did not constitute sexual harassment, notwithstanding the fact that several female employees complained about it. And finally, the board struck down a rule that required employees to be courteous, polite, friendly to customers, vendors, suppliers, and coworkers, and forbade disrespectful conduct or the use of profanity, since such rules could forbid complaints about working conditions to customers. Here again, the board in some cases takes a very, very fine view of the definitions and intentions that the employers have in these rules. Not surprisingly, the board typically tends to apply these same concepts about workplace speech to social media cases, where employers may have rules that restrict what employees can say about the company or the coworkers online. In doing so, the board has struck down a number of different employer social media policies that can forbid things such as disparagement of the employer, its supervisors, or its policies on social media. Those are forbidden, or policies that keep employees from identifying themselves or their employer in social media, or from using the employer's logo in their postings. Employers can't have rules like that. Also rules that forbid employees from engaging in, quote, unprofessional communications, or where employees are disciplined for criticizing employer management styles or treatment of their coworkers. In short, the board views such employer restrictions as impacting an employee's ability to discuss issues affecting his or her wages or working conditions, or whether they may wish to form or join a labor union. The consequences, again, of such violations can range from invalidating the unlawful work rule or policy to overturning an employee discipline, and again, awarding reinstatement and back pay. So as lawyers, we love to tell people what they can't do, but you're probably wondering what it is you can do if you're an employer to adopt a valid social media policy. Well, the good news, I guess, is not all employer social media restrictions are unlawful. For example, an employer can discipline an employee for posting individual employee complaints not involving overall criticisms of workplace policies, or which don't solicit group discussion among other coworkers, since those actions may not constitute what the law calls concerted activity. Also forbid internet postings which violate the employer's existing race or sex harassment policies. But here again, note the apparent conflict in this with the Fresenius case, which we cited in the materials just a couple pages ago. Also, the employer can require the employee to comply with the FTC rules about what you can and can't do regarding disparaging a competitor's product of the employer, or indicating that the internet posting is the employee's own opinion and not that of his company. In short, employers must closely examine their work rules and policies to ensure that they're dealing with legitimate areas of employer concern, and that which aren't capable, even in light of the board's strained analysis sometimes, of being interpreted or applied to restrict conduct which the board considers to be protected by the Act. Now we'll go over to Art to talk a little bit more about computer monitoring and data access.
Thanks, Mike. We're going to get technical here, so hopefully everyone has their iPads out ready to take notes. So we're looking at what are the rights of the employer to control the use and to access company computers and devices like iPads, iPhones, versus employee-owned devices. The problems that we have are who controls the data, who has a right of access. When we're talking company computers, it's an easy problem. The one who owns the computer or the device is the one who also has virtually complete control over anything that's on there. Though still, there are policies and agreements that I'm going to recommend that you adopt, and if you don't have those, we can, of course, provide them to you. The problem is when you have employee-owned devices, you have a question as to who has the right of control, who has ownership interest in data that is on there. Now, the best answer is you should only use company-provided devices, not allow employees to use their own devices. Left to their own devices, trouble ensues. However, I think in many workplaces, that's just not a practical solution to have only company-provided devices. Because even a thumb drive provided by an employee is very hard for an employer to restrict the use of. So what we need are certain agreements, policies, and notices. First, let's look at employee personal email accounts. If it's the company email account, like mine at Thompson Coburn, fair game for the company, the law firm in this case, to look at anything that's in there. Even if I considered it very private and embarrassing, it's on a company-provided email account on a company server. They can look at it without my consent, and I should expect that they're going to do that. The same is for all the data that's stored anywhere on a company-owned or controlled computer or server. Now, the issues come into play under a whole bunch of federal laws, but we'll start with Federal Stored Communications Act, but the Computer Fraud and Abuse Act is very similar. Now, I'm not going to go through the elements of these acts, but they're all very similar, and they get at, you need authorization before you access and either damage, wipe a drive, or disable somebody else's computer device. So that raises a need for policies. Privacy is a matter of expectations. We normally, when we're in the bathroom, we have an expectation of privacy. But if there's a big sign that says, hey, there's no expectation of privacy in using this bathroom, the law would say, hey, you used it, knowing that there's no privacy. So the workplace is very much like that. So we want a policy that says, when you use our system, you have no expectation of privacy. We also want agreements in which an employee agrees, consents in advance that we can access any device that's used in connection with work. Now, this is especially important when we're talking about personal devices that the employee provides. We want an actual agreement. And three of the big points that are covered in these agreements, though there are others, are one, even though it's on your device, the data is still only the company's. And at the end of employment, it goes back to us. You can't keep a copy. Second, we have a right to access anything that's on that device if you're using it in connection with work. The third is you absolutely can't store on any of these devices any information that contains HIPAA data or personally identifiable information. That would be things like names, telephone numbers, social security, and addresses from which someone could steal that information and create false identities. And I'm sorry that being the one who's controlling the slides, I forgot to skip to it. So now we're going to go back to traditional labor law and Mike Duffee.
Thanks, Art. As Art told you, employers have legitimate needs to protect trade secrets and other confidential business information. And to that end, a lot of employers have adopted policies concerning the use of the Internet, their Internet, to preclude employees from engaging in non-work-related solicitations, even if these can sometimes include union-related solicitations. The Labor Board decided a case in 2007, registered guard, to that effect, although I will tell you that the current board is soliciting briefs in a case that very well may overturn that decision sometime in the next several months. And other employers have adopted what they call media relations rules, which forbid employees from talking to the media or for talking to government investigators without clearing those kinds of discussions first with the company or its legal department. Well, while the board claims to understand that an employer has some need for confidentiality in the workplace, all of these policies present potential violations of the Labor Act. For example, the NLRB in the last couple of years has invalidated employer rules which, for example, prohibit employees from discussing confidential employer information with coworkers if that term could be construed as forbidding discussions of wages or working conditions. The Labor Board for many, many years has held that employees have an absolute right to discuss among themselves or even with a third party the amount of their wages, their benefits, and things related to their working conditions. And any rule that forbids discussion about that is prima facie unlawful. The board has also struck down rules which preclude employee discussion about the details of their jobs or the company's businesses or work projects with third parties outside the company. Again, protecting the employee's right to discuss these kinds of things with a potential labor organization that may want to represent them. And also, the board just flatly will not allow restrictions on employee contact with the media or with government investigators, specifically government investigators. They take a real offense to that, I guess, because it hits home pretty well, without prior employer approval. Now, this line of cases can even impact the extent to which an employer can require employees to keep workplace investigations confidential. The board closely scrutinizes rules which limit an employee's ability to discuss ongoing workplace investigations. For example, in a case from about 2 years ago, Banner Health System, the board struck down an employer rule, which probably most employers have, that simply forbids employee discussion of matters that are under workplace investigation. The board said for a rule like that to be valid, the employer has to show in each case that he's trying to enforce that rule that the confidentiality policy, as applied, is supported by legitimate business justifications. For example, witnesses who might need to be protected unless you were able to keep the investigation confidential, or the possibility that evidence might be destroyed, or that testimony might be fabricated if employees understand that some particular one of their coworkers is ratting them out and they want to protect themselves, or their need to prevent a cover-up. But what do you do as an employer when the Equal Employment Opportunity Commission is telling you that sex harassment investigations, for example, must be kept confidential? Can that be reconciled with the board's position in Banner Health? We think no. That's kind of an irreconcilable conflict between two different federal agency sets of regulations. So perhaps in recognition of this conflict, the Labor Board's Division of Advice, which is in the General Counsel's office, about a year ago suggested in a particular case in qualifying the legality of an employer's work rule, came up with some language that an employer might use to protect the validity of its rule, saying that, well, if you have a situation where in a particular set of circumstances we need to protect the confidentiality of the investigation, well, then employees can be held to comply with such rules. Here again, I think the board's still thinking about this particular issue, and I think they realize that perhaps they may have gone a bit too far in Banner Health Systems, but we'll have to see how that develops over the next several months and year or so. And again, we've told you what you can't do, so what will the board allow in terms of confidentiality policies in the workplace? And fortunately, there are some restrictions that the Labor Board has allowed. For example, restrictions on employee public disclosure of trade secret or proprietary information, so long as that doesn't include wage information or benefit data. Restrictions on public disclosure of pending corporate plans, which could implicate federal securities rules, insider trading. Forbidding disclosure of patient or coworker personal health information, which here again is dealt with in other federal regulations, so it's nice that the board's trying to be consistent for a change. Requiring that social media postings, as we mentioned earlier, conform to Federal Trade Commission rules when employees are supporting their employer's own product or disparaging that of a competitor. And finally, limits on disclosure of workplace investigations, as we just discussed, where necessary, to protect witnesses or evidence from disappearing. Now over to Art to talk about issues that relate to post-employment considerations.
We're now in the home stretch. Employment relationship is over, but we don't necessarily trust our former employee. So what can we do to protect ourselves? I also wanted to mention, as a bit of digression, on the Illinois law that we expect to be signed by Governor Quinn on not asking about criminal background until after a conditional offer of employment or a job interview has been made, that is intended to go into effect in January 2015, and that it will require Illinois-based employers to probably change their employment applications if they ask for disclosure of criminal information on their records. Now, we've gotten rid of, or the employee's gotten rid of us, and we're suspicious about what they're going to do. Are they going to file a specious workers' comp claim, file for unemployment benefits? They're going to compete against us. So those are the concerns that we're looking at. So we want to search the company's email address, that is the employee's email address that that the company provides, or that the employees provided us authorized access to. If it's a Gmail account or some other personal account, I think we need to talk about whether we still have authorization to access that account. But if it's the company's account, we clearly have access. And we may want to hire a forensic expert, not just go through it ourselves, because we may be changing evidence while we go through those emails. So there are certain steps which we can help take you through in going through emails and other communications to see if the employee, former employee, was engaged in setting up or competing with us beforehand. We want to monitor social media, but not do so in a surreptitious way, such as pretending to be someone else to get access to someone's restricted Facebook account. But we want to be looking at that. LinkedIn has now become a great way to find out someone just announced that they have a new job with a competitor, despite their non-compete agreement. If our concern is workers' comp, well, we can have someone videotape. We'd also want to be looking at what if they've been posting on their Facebook page. Very often the Facebook page is not restricted and anybody can just put in that person's name and see all that stuff. Same thing goes for unemployment compensation claims. Now, an area of law that I'm involved in all the time is enforcement of non-competes and allegations of misappropriation of trade secrets. There's a whole bunch of laws here, but let's assume that you have an agreement that says either you won't compete with us, you won't solicit our customers, and it's been well written, that it be enforceable in court if we can prove that it's being violated. But there's also, even if we don't have that, there's certain laws that prohibit the misappropriation of trade secrets. The one that most comes to mind, which is referred to at the very bottom of the page, is the Uniform Trade Secrets Act. That I think 49 out of 50 states have this Uniform Trade Secrets Act that says you cannot misappropriate an employer's trade secret. Of course, it has to meet the requirements of being a trade secret. There's pretty good civil remedies there. You can get an injunction, attorney's fees, you can get damages, but doesn't have the force of criminal law. On the federal level, federal law is becoming increasingly important, and that trend should continue. So first we have the Computer Fraud and Abuse Act, and we have the Electronic Computer Privacy Act, and the Electronic Stored Communication Act. All of these are pretty similar in how they apply in prohibiting an employee from going into our computer system and downloading all of our trade secrets. So there can be criminal violations, and there's certainly civil remedies, including an injunction, damages and attorney's fees under these various acts. What's increasingly becoming important is the Economic Espionage Act of 1996, which provides for 10 years in prison for stealing trade secrets. Now, this most typically is applied to when someone from China comes over and steals trade secrets from Hewlett-Packard. Plenty of prosecutions there. But it doesn't have to be international. It can be purely domestic. It can be purely your employee steals your most secret information to start up a competing business or to help another business for which he gets paid a starting bonus of $100,000. The Economic Espionage Act is your remedy. That's an extremely powerful tool. Now, the counterpoint of that is that the Economic Espionage Act does not have any civil remedies. It's purely criminal, and so in order to go forward with it, you got to convince the U.S. Attorney's Office to prosecute. But that may change, that Congress might, if they ever pass any law, could pass a Defend Trade Secrets Act, which would allow civil suits to be filed under the Economic Espionage Act. That is all of our presentation. I'm going to turn it back over to Mike as to what questions we see on the board.
Right. We had a question, which is actually pretty good one, on the extent to which the employer can get into the its employee's computer and look at varieties of things, what websites they may go on, their emails, and even if it's one of their private email accounts, the extent to which the employer can do that. If you have a policy, which we obviously would recommend, that says that the use of your electronic equipment, your telephone, your computer system, your internet, is company property, and that the company reserves the right to monitor that, to monitor compliance with other company policies or, proper use of those instrumentalities, there's no problem in accessing that, even if it might be the employee's own personal email account, which they happen to use frequently on their own computer. But again, strongly urge a good, thorough electronic communication policy to make sure that there's no expectation by the employee of privacy in those communications.
Right. I'm going to comment on that. If it's an employer-owned computer and device, then I have very little concern that there's an employee privacy issue. However, I would still have at least a good policy. Now, if it's an employee-provided device, like the iPad that I have, but I have work stuff, then I'd have concern about the employer trying to gain access over that device by grabbing it and taking a look at it or monitoring. There, I think it's important to have the employee's consent, and we do that in advance. And we have all these forms, these agreements, these notifications that should be sent, so please feel free to email us, and we're happy to provide that to you. Thanks very much for listening. If you have any questions, please email one of us, and we'd be glad to contact you or email you back. Thanks.
Thank you.